Okay, let's get started. I'm Ray Randolph, and I'm the moderator. Before I say anything further, I want to invoke the Justice Scalia rule, no unauthorized recording of the proceedings. We'll proceed this way with Mr. Wise will be first, and then Professor Cupp will follow him. I have to admit that I was absolutely surprised. This is not a topic when we talk about animal rights or animal personhood or even animal law. It's not something that I've studied at all. But I was surprised that there are 144 law schools, I'm told, that have animal law courses now. And there are 5, I thought there was only 1, but there are 5 law reviews that are now dedicated. Is that right, 5? Or?
There have been at least 5, I believe.
Yeah, dedicated to this very subject. So like I said, I just, it's something that's eluded me and something I never thought about. And we don't get that many cases involving animals, although as I was talking to Dean Reuter, it suddenly occurred to me that a number of years ago, we hear 4 cases a day. And I sat on one of these days and with the 4 cases, and every one of them involved a bird. I never really put this together, but the first case dealt with Virginia rounding up Canadian geese around the airports because they're very dangerous, and they get sucked into the jets and it can cause tremendous damage. And they were protected. They're protected by the Migratory Bird Treaty Act, and it's a felony to molest them unless you have a permit from the Interior Department. But what's happened in this region anyway, even though it's the Migratory Bird Act, the Canadian geese don't go back to Canada. They maybe should be called Virginia geese because they live here year-round now. The largest populations don't migrate at all. And you might think that's global warming causing that, but it's just the opposite. It's not cold enough in Canada to get them up there. So the second case involved the Endangered Species Act and the protection of a bird called the Queen Charlotte's hawk, I think it was, or falcon, I'm not really sure. And the third case dealt with the United States Department of Agriculture inspecting chickens that were being harvested for food. And then the fourth case was a criminal case, and it was entitled United States versus Swan. So we had 4 bird cases. Well, anyway, I was thinking about the Migratory Bird Treaty Act when I was looking over the material last night, and I was talking to my cat, and his name's Bud, and he seemed rather enthralled with the idea of personhood. But then I explained to him the Migratory Bird Treaty Act, and we have a couple acres in Potomac, and he didn't seem to relish the idea of possibly committing a felony if he took a particular kind of bird that migrated. But then I assured him that if he ever were charged, he would get a jury of his peers, and he kind of lit up at that. Well, anyway, we'll start with Mr. Wise.
Just want to make sure I don't go over my time. Once I start talking about animal rights and the non-human rights. Yes.
I forgot to mention something. We're going to take questions afterwards, and there are little cards on your table. So if you write down your question, we'll gather them up and then proceed from there. Thank you.
No problem. The judge's story actually reminded me of an email interchange I had with Judge Posner. I had the privilege of debating him and Professor Epstein on C-SPAN once, which was a memorable experience. And Judge Posner and I have stayed in touch over the years, and he sent me an email a few years ago saying that to tell him that his cat, Mitzi, had told him to remind me that mice don't have rights. So, yeah, duly noted. Okay. Well, I was coming here to talk about the issue of animal personhood, which in my mind, has become an extraordinarily broad issue, and I wrote about it in the abstract for several years. I wrote about, I don't know, 10 law review articles and 4 books. And then once the Nonhuman Rights Project began to turn itself towards litigation, all of a sudden the abstractedness kind of fell away, and we were faced with the problem of looking at jurisdictions and trying to figure out how to litigate the sorts of ideas that we had been working on in the abstract, specifically. And we learned quickly that the law of the 50 states was dramatically different, that there were some states that we thought might be more favorable to us and some that we thought were not going to be. And so right now, I have become an expert at litigating whether or not a chimpanzee is entitled to a common law writ of habeas corpus in the state of New York. And that's really what the Nonhuman Rights Project is thinking about these days, looking at specific animals, looking at specific causes of action, and then looking at the law of all of the states to see where we might be able to have the best fit, because there is an enormous diversity. So we have for a long time, our problem as that there is this great wall, which I've spoken about a number of times, this great legal wall. And on one side of that wall are legal things. The other side are legal persons. So legal persons right now are all, with respect to natural persons, all but only human beings. And on the other side of that wall is the rest of God's creation. All of the non-human animals are there. And non-human animals have an incredible diversity of range. Beetles, horses, chimpanzees, whales. They're extraordinarily diverse, different. There's 1 million species of animals. And so we really, in the Nonhuman Rights Project, don't talk about animal rights because we talk about the right of a specific non-human animal or the right of a member of a certain species. And we don't talk about rights, we talk about a specific sort of right. So in our litigation in the state of New York, we're talking about the common law right to have a writ of habeas corpus issue on behalf of a chimpanzee that would protect his common law right to bodily liberty. And probably the reason that Judge Randolph would not encounter our suits is that we do focus on the common law. And one of the reasons that we do that is because the common law, is the kind of law that judges make, and they're supposed to make it. That's what the common law is. When you're in federal court, you tend to interpret statutes or constitutions or treaties. They do that in state court as well. But they also they also make the law in the interstices of statutes, of constitutions, and we're looking to be able to bring our cases in front of common law judges and asking them to take a look at the common law, which we argue is supposed to change as experience accrues, scientific evidence accrues, morality changes, and we don't have to worry about a judge talking to us and saying, well, what did the legislature mean when they said the word person in that statute? Did they think about chimpanzees? Because the answer almost certainly is, well, no, they weren't thinking about chimpanzees. However, we would argue that they should look at the common law and they should begin to think of expanding it based upon the 3 things that I was talking about. And we argue to the court that at one time, all human beings were not on that side of the wall. They weren't all persons. For many years, we had black slaves, women for many purposes, children for many purposes. They were on the other side of that wall. They were seen as legal things for many and sometimes all purposes. And there's been a centuries-long struggle to kind of bring them, through the wall or around the wall and put them into the category of persons. And on the other side, there are many persons who are not human beings, because we have found that when we go in front of a court, the judges have the idea that persons and humans are synonymous. And so the very first problem we have is to try to persuade, with sometimes not much success, but try to persuade judges that human beings and persons are not the same thing. So there are examples in the United States, corporations, ships, states, they may be persons, but they're also also an extension of human activity. But we look to other common law countries, for example. We point out to the judges that in pre-independent India, that a court held that a Hindu idol was a person, that a mosque was a person. In 2000, the Supreme Court of India held that the holy books of the Sikh religion was a person. And in 2012, there was a treaty signed between the indigenous peoples of New Zealand and the Crown that held that a river was a person and it owned its riverbed. And we argued to the court, and there's some great law in the state of New York on that it's not a matter of determining, who is a human being, and if you're a human being, then you can be a legal person, or you are. But it's a public policy issue as to whether or not the entity in front of me, ought to be a person, because persons are visible to the court. Persons have rights. Persons have the capacity for an infinite number of rights. They count. They're the masters. Things are the slaves. Things don't count. Things are invisible to courts. They don't have rights, and they don't have the capacity for rights. So we have to try to persuade the court that they should look at our client and begin and move at least our client out, and perhaps our species out of the category of thing into persons. Now, we chose from among several species. I had written about them for years. One of them was all four species, four of them actually, all four species of great apes: chimpanzees, bonobos, gorillas, orangutans, two species of elephants, and some species of cetaceans such as orcas. And the reason we chose those animals is because we have looked at the science for years. I've been speaking to scientists about this for more than 25 years, and we understood that scientists had been working, studying these animals in the wild and in captivity, and they understood that these animals have extraordinarily complex cognitive abilities. The cognitive abilities that they have are very similar to ours, so it's easy for us to understand them. And so we first began to look at what sort of things might a common law judge value. What kind of values and principles do common law judges see every day? They're taught every day, or they were taught in law school, and that they are used to working with. And so we didn't have any preconceptions, and just tried to find out what sort of arguments might we be able to make. And so it took a number of years, but really we understood that liberty and equality kept popping up, over the centuries, liberty and equality. And so we began to try to understand how we might be able to make those kinds of arguments. Why should our chimpanzee be entitled to writ of habeas corpus as a matter of liberty or a matter of equality? And it seemed that as a matter of liberty, which is a non-comparative right, a liberty right you're entitled to because of who you are, what your status is, we saw over and over again that courts valued autonomy and self-determination as a liberty right, that it was extraordinarily important to them, so much so, as we sometimes talk about in our New York cases, that if a competent and autonomous human being decides to say, I don't want medical treatment, I'd rather die in a hospital, that their autonomy will be so important that it will trump the state's interest in life itself. Then we looked as a matter of equality. What did equality mean? What kind of arguments can we make? And one of the arguments is equality in a 14th Amendment kind of language would say that at the minimum, you have to have a rational means to a legitimate end. And we argue that chimpanzees, as I'll tell you in a second, are autonomous and self-determining beings. And to discriminate against them violates equality, because the end is the slavery, the enslavement of autonomous beings, which is not a legitimate end. another thing, we took a page from the Romer case, and we argued that the New York State courts should consider the Romer case, which said in one sentence, one thing you can't do is choose one quality and then say an entity or their gay people did not have rights across the board. And we say, just looking at the fact that a chimpanzee is a chimpanzee, that's his species. That's one quality about him. You can't simply call him a chimpanzee and then say, you are a thing, you don't have any rights, you never will have any rights, and we can keep you in prison, in a cage, for your entire life. So we think it violates common law equality, common law liberty as well. And we kind of wrap this around a common law writ of habeas corpus, and we note that habeas corpus has been used for 250 years, at least, more than that, to allow those who are legal things to come in and argue that they are legal persons. One of the most famous cases is the Somerset versus Stewart case, which I was so fascinated about that I took 3 years out to write a book about it, Though the Heavens May Fall, which kind of set out the way the case was litigated and how it was that James Somerset's lawyers were able to go before Lord Mansfield and move him from the status of a legal thing to a legal person. And one of the reasons, in fact, that we picked the state of New York as our first case is because the Somerset case is indeed part of the common law of the state of New York. So we filed these suits, and I guarantee you there's a lot more going on, but that's kind of at the very top level. We filed 3 suits on behalf of 4 chimpanzees in the state of New York in December 2013. And I think it's fair to say that the judges were not clear how to deal with us. And we got 3 different ways of dealing with this at the Supreme Court level, which is the trial court level, and then it got really interesting because we then appealed, and then we've now gotten three wildly diverse appellate actions. And one of them, when we filed our appeal on behalf of Hercules and Leo, 2 chimpanzees who are being used in biomedical research on Long Island, that when we appealed, and I then filed a motion to admit me pro hoc vice, we got something back saying, we deny your motion to appear pro hoc vice on the grounds that we have dismissed your appeal. Without briefing, that was the end. So they said we didn't have a right to appeal, which we thought that they were very wrong. So we're refiling it in another place. We then went in front of the third department, involves Tommy, another chimpanzee, and they ruled that Tommy could not be a person, which was really what we were arguing about. And they relied upon my erstwhile opponent, Richard Cupp, 2 of his law review articles, and as well as other things. But they really said 2 things: that Tommy doesn't appear to be part of the social contract, which we also think, well, it's true. Tommy's not part of the social contract. But we've also tried to point out to the court that there's a lot of petitioners for habeas corpus who I think it's fair to say are not part of the social contract. We talked about James Somerset. We talked about the Hottentot Venus case in the early 19th century, where you had a Hottentot woman from South Africa who was brought to England, and they were able to bring a writ of habeas corpus on her behalf. You have the Guantanamo folks. I think it's fair to say that not only are they not part of our social contract, but they'd like to do away with our social contract. And they also have been allowed writs of habeas corpus. And if you look at anthropological research, as we have, there are all sorts of indigenous peoples around the world who don't understand. They don't even have a word for society. They don't have a word for contract. They are not the kind of beings to be part of our social contract. And we argue that chimpanzees are not part of the social contract either. But that doesn't mean that you should be able to imprison them for life, because another thing we did was we went to some of the experts around the world on chimpanzee cognition, and we found 9 of them who wrote affidavits from Japan, Germany, Sweden, England, Scotland, the US, and they sent us 100 pages of affidavits that we filed with the courts, in which they were able to explain to the courts what kind of extraordinarily complex beings we are dealing with. And we asked them to focus on parts of their cognition that kind of together showed that they were autonomous and self-determining beings. And it was clear that they're conscious, that they're self-conscious. They even have a theory of mind. They understand what's going on in the minds of others, that they understand that they're individuals who live through time, that they were there yesterday, they're going to be there tomorrow. They engage in what's called mental time travel. They can imagine, they can remember the past, they can imagine a future, and they can plan for that future. And we gave them several examples of chimpanzees who plan for their futures. They engage they have some sort of moral agency. They have a language, or they engage in referential and intentional communication with each other. If you want to call it language, you can. If you don't, then you can call it whatever you want, but it looks a lot like language to me. They understand numbers, and they have cultures. They have a material culture. They have a social culture. They have a symbolic culture. And one of the best examples I saw is the field of chimpanzee archaeology. In the Thai forest on the Ivory Coast, you have Professor Bush, who has done archaeology work in a certain area where they use different kinds of stones to open up these nuts. And he was able to find that they've been using those stones for at least 4,300 years in that area. So over 225 chimpanzee generations, over 4,300 years, they have passed that material culture down from from parent to child, and it's clear that these chimpanzees do indeed have that culture. What time is it? Am I?
You've got a couple more minutes.
A couple more minutes. Okay. So we brought all of this in front of the courts, and it's clear that the courts really liked our facts. No one has said anything bad about the facts. The judges have complimented us on them. But it's also clear that as a matter of law, they don't quite know how to deal with us, and they're worried about ruling in our favor. In the fourth department, involving another chimpanzee, Kiko, they handed down a brief decision, but they also, in that brief decision, they twice assumed without deciding that Kiko was a person. And the reason we lost is that they argued, the court didn't argue, they told us that anyone who seeks to move a being who's involved in a writ of habeas corpus, who seeks a writ of habeas corpus from one place of confinement to another place of confinement, cannot use a common law writ of habeas corpus. Well, we had, in oral argument, I had explained to the court, because they asked me that New York was filled with cases involving child slaves, apprentices, mentally ill folks, people who have Alzheimer's, where they had been moved from one place of confinement to another place of confinement. Now, obviously, chimpanzees, if we win a writ of habeas corpus, cannot be just thrown out onto the street. They will die or they will be killed. And so we want them moved to a place like Save the Chimps, which, as far as I'm concerned, is kind of like Chimpanzee Paradise Island, where they made a huge artificial lake. They have 13 3-acre islands on there, and about 25 chimpanzees live on these islands. And it's a great place, I think, if you're a chimpanzee. And so that's the place of confinement. We're moving Kiko out of a cage, or Tommy out of a cage, in New York State to South Florida, where they will live outside with other chimpanzees. They will be out of their solitary confinement because they are social animals, and they will be living an entirely different sort of life. So the courts did not agree with us. So we actually have appeals moving up for all of our cases to the Court of Appeals. And then we're also devising other sorts of causes of action, which we are well into them, and we're trying to get some of them published in law review articles so people like Professor Cupp can maybe point out where we're wrong, and we can think about it. And then we are thinking about what other animals. We're going to be filing a lawsuit, likely on behalf of elephants in the next few months in another state, whereas we do the same sort of thing. We visit the elephant experts from around the world, and they give us the benefit of all of their work, and they show us as well what extraordinarily complex cognitive abilities they have, that they are autonomous and self-determining. And the thing that has concerned us is that if courts rule against us, it's difficult, we think, to rule against us humbly in a rational way, because what they do is they are assigning an incredibly intelligent being who is autonomous and self-determining. They are assigning him for the duration of his life to continue to be thought of as a thing, to not have the capacity for any rights and to not be able to enforce even any protections. And they're then forced to live in a way that no autonomous being should. These animals truly understand the past. They truly understand the future, and they recognize that they are in something they don't like and that it could go on for the rest of their lives. They indeed plan. I'll just tell you one brief story. Do I have 30 seconds or? 30 seconds. One of our experts went to a zoo and saw that there was a chimpanzee who was on a little island. People would come see him in a zoo, and he didn't like it. And so what they found that he was doing is people would come in, and he would start throwing rocks at them. And they looked at him, and they realized that he would get up very early every morning, go around the island, find rocks, hide them. As soon as when the people came in to look at him, he would start pelting them. The zookeepers then tried to find the rocks, so he would find them and then hide them from the zookeepers, and he'd wait for the afternoon. When they came in, they would start pelting him with rocks. He clearly understood, that he had a future and there was something that he might be able to do about it. Thank you.
Well, thank you all for coming today. It's an honor to be able to join all of you and be able to speak on this subject. I appreciate the Federalist Society for hosting this and for inviting me to attend. I also appreciate Judge Randolph for taking time out of his very busy schedule to serve as our moderator. And I also appreciate Mr. Wise coming here and speaking. And as I always say when I talk about him, I respect his work and enjoy getting to share a podium with him. I would describe myself as an animal welfare supporter. I think that there is a human responsibility for animals that is significant and that is deep, but I don't think that that should be changed into a focus on legal personhood or a legal personhood paradigm. In my view, this is not a question of whether law should evolve or whether it should stay exactly the way it is with regard to how we treat animals. I take the position that law is definitely going to evolve with regard to how we treat animals, and that this evolution is a good thing. There are at least two reasons we're going to evolve to be more compassionate, I think, with regard to how we treat animals over time, and indeed are already in a period of significant evolution. One of these is how society has changed. I was talking to someone before we got started and mentioned that my parents were born on contiguous farms in Indiana, went to a one-room schoolhouse. They had lots of animals around, brought me up to love animals, but for them, the primary interaction that they had with animals, or our society generally 150 years ago, my parents weren't that old, but even when they were on farms, a lot of people were moving to the cities, our primary relationship with animals would have been economic. The animals that we encountered in our day-to-day lives would have been our farm animals, and we had economic uses for them, and of course, that colors the way we look at them legally. Now, you see where I'm going with this. Now, easy to say here in this Washington, D.C. crowd, but I'm from Southern California, the same thing. Most of us live in an urban, suburban society, and I even grew up in a suburban society. My parents got me out of Indiana and to a suburb, and that's just the way society has changed. So when we come into contact with animals on a daily basis now, as most of us do, it's usually animals that we're interacting with because we get emotional utility from the animal as a companion animal rather than as economic property. So it's just inevitable that having that change is going to change the way we look at animals, and already has been. The second reason that I think evolution is both good and inevitable is science. We've learned so much more about animals' cognitive abilities, about all aspects of animals. There's much more about animals that we don't know than that we do know. I suppose we could say that about our own brains as well. But as we learn, science always leads to evolution in legal standards, and this is going to be no exception. We're going to evolve to have more compassionate uses of animals over time. We're already in a significant period of this, and it's a good thing. The question to me is not whether we evolve, rather the question is how we should evolve. I see two untenable positions and one centrist position. You won't be surprised to hear that I will describe myself as following the one centrist position. There may be other positions as well, but let me throw out a couple of untenable ones, I think. One would be to say everything's fine the way it is right now with regard to how we treat animals. We've evolved, we're now compassionate toward animals, everything's great. Well, it's unrealistic for one thing. Change in law takes time, and we're going to be continuing to evolve based on changes we've already made in our society and with science. But it's also, we're going to learn more, and our attitudes are going to change more. It's just untenable to say, let's keep things exactly the way they are with regard to the level of protections, the level of concerns that we have right now. The other untenable position would be to reshape the law dramatically by saying an animal is a person, a non-human animal. Whenever I say animal, I'm meaning non-human animal, is a person. An approach that could have very dangerous, unknown and very dangerous consequences for our legal system. Viewing both of those approaches as untenable, I support what I view as a centrist position of saying, let's stick with focusing on the entities that are really going to make decisions with regard to how animals are treated. That's humans. Keep the focus on human responsibility, but at the same time embrace evolution and try to guide law toward a good balance and appropriate results that show proper respect both for humans and animals as we evolve our positions on different legal issues. So within the community of folks who talk generally about concepts of personhood or rights with animals, there's sometimes division on whether there should be a focus primarily on animals with a capacity to suffer, sentient beings, or whether the focus should be more on animals that are really intelligent, like chimpanzees. I'm going to focus more on the latter, both because, as Mr. Wise discussed, that's where his lawsuits are mostly focused, and also because there's a connection between the two. If we open up the door, break through the legal wall between humans and animals, it's only a couple of stepping stones away to imagine that there would be efforts to base personhood on sentience or capacity to suffer as well. So the two approaches, to me, are not completely unrelated. They could be looked at as sequential rather than distinctly separate. My first point is that legal personhood and rights are anchored in the human moral community. As explained by philosophy professor Carl Cohen of the University of Michigan, animals cannot be the bearers of rights because the concept of right is essentially human. It's rooted in the human moral world and has force and applicability only within that world. Our government is based on the ideal of moral agents coming together to bring a system of rules and create a system of rules that entail both rights and duties. Being generally subjected to legal duties as well as rights is the foundation of our legal system because it's a foundation of our entire government. We do stand together in the form of some form of social compact, or one might call it a moral community, to uphold all of our rights, including our inalienable rights. As stated in the Declaration of Independence, to secure these rights, governments are instituted among men. We'd be hard-pressed to convince most Americans that this is not important, as from childhood we're taught that it's a bedrock of our social structure. It's not surprising that the ABA's section on civil liberties calls itself the section of individual rights and responsibilities. That doesn't mean that every specific protection has to correspond to a specific duty. The connection between rights and duties is broader than that. In general, we insist that rights bearers in our community be subjected to responsibilities along with their rights, regardless of whether a specific right or limitation requires or does not require a specific duty to go along with it. It misses the point, in my view, respectfully, to argue that rights and responsibilities are irrelevant because we can call freedom from slavery a bodily liberty interest that doesn't require capacity and that can't be waived. I suggest that it doesn't matter in this context whether freedom from slavery requires capacity, since an incapable human's rights are not anchored in the moral, or are anchored, in the moral community of humans, even if they can't make moral choices themselves. This all still boils down to the problem that a chimpanzee, although a wonderful, amazing creature that we need to think a lot about how we're going to treat in our legal system, should still not be considered a person within our intrinsically human legal system. Our question is, who is a member of society for rights and for purposes of rights and protections? In other words, who is a person? It's often argued that if we give corporations personhood, I think Mr. Wise alluded to this maybe to some extent in his talks, if we give corporations personhood, we should also give intelligent animals personhood. They're actually living and breathing, and corporations are just artificial things. The problem with this point of view is that corporations are given personhood for the purpose of representing human interests and human duties, human rights and human duties. We have a proxy in corporations for the rights and duties of humans. They are creations of humans designed solely to further human interests, which are very different, of course, from animals. It's also argued sometimes that since we give personhood to children and to mentally incapable adults, we've also got to give personhood to animals who have strong mental abilities, strong mental capacities. If we think about it, you're going to find some situations where highly intelligent chimpanzees, for example, will have higher mental capacities than the most severely limited humans would have. This argument is sometimes called the argument from marginal cases. But the argument from marginal cases, of course, has an unsettling tone because none of us want to think of any humans as being marginal. The view of the overwhelming majority of people is that all humans have distinctive and intrinsic human dignity regardless of their capabilities. And this may have cultural, religious, or even instinctual foundations. All of those foundations on their own would present a huge challenge to saying, let's create legal personhood for animals, but they're not the only reasons to reject the argument. Children and mentally incompetent adults are part of society's community, even if their own moral agency is limited. Humans are the only known creatures, there might be some in other worlds that we don't know of yet, but for now, they're the only known creatures where moral agency is sufficiently strong to function in our society, a society such as ours, is the norm. Extending rights to our fellow humans, regardless of whether they meet this norm, is a pairing of like kind where the kind category has special moral significance. The significance of the norm being the only creatures who can rationally participate in a society such as ours. Morally autonomous humans have unique natural bonds with children and with mentally incapable adults, and thus denying rights or personhood to them also harms the interests of society. We are all in community together. Children are our children, and mentally incapable adults may be our spouses, our children, our parents, or our siblings. We've all been children, and we all, of course, relate to children in a very special way. Further, we all know that we could become mentally incompetent, And this reminds us that humanity is the principal defining characteristic of a mentally incompetent person, not the person's mental incompetence. Allowing humans to make trusts for companion animals doesn't make them persons. This is one of the things that's talked about in Mr. Wise's argument. I don't think Mr. Wise mentioned it. He may want to come back to it to show that I'm wrong with this, I don't know, but I'll briefly make this point. There's an argument that in New York you can make trusts for animals, and that makes them persons. So we're just now figuring out that they are persons, so let's assign their autonomy interests. He'll correct me on how I'm saying that, I'm sure. In any event, my position on that would be when a state creates a statute saying that an animal can be a person, not a person, that an animal can be named in a trust, they're not trying to say that animal is a person. They're trying to look to the person who has the companion animal to give them some peace of mind when they're creating a trust so that they can care for their animal and also to provide good protection for those animals. Final points. Why all of this matters. One of my deepest concerns, and as I struggle with some of these issues sometimes and try to think things through over and over and over again, this one comes back to me a lot. One of my greatest concerns is that if we have legal personhood for intelligent animals, that presents an unintended long-term danger to the most vulnerable humans. The most vulnerable humans are people with mental incapacities. I want to be very clear as I raise this concern. Supporting animal personhood does not imply that one wants to reduce the dignity interests of mentally incapable humans. Indeed, my understanding is that the chimpanzee lawsuits that are now being litigated seek to pull smart animals up in legal consideration rather than seeking to push less capable humans down. However, despite these good intentions, there should be strong concern that over time, allowing animal legal personhood could unintentionally lead to erosions of protections for the most vulnerable humans. I don't think the sky would fall immediately if a judge or set of judges said animals should be legal persons, but I'm more worried about things over time. Over time, both the courts and society with this new paradigm might be tempted to look not only at intelligent animals as being more like humans, but also on the other side of the same coin, to start thinking of less intelligent humans a little bit more like the animals. So I think we should be very concerned about how far animal personhood and rights might go. As Mr. Wise mentioned, a goal of these lawsuits is to break through the wall between humans and animals. Mr. Wise, I think, recognizes this is a big deal. This isn't some modest incremental step. There is this wall. I think I agree with that. And the objective is to break through. Well, if we do this big deal, we have no idea how far the legal consequences might go. In the real world, no judge exactly holds to any single moral academic philosophy or other academic theory when she's making decisions about real-world cases. She has to be very pragmatic. She has to be very practical and recognize or try to think about seriously what the implications, bigger implications might be of taking this little step. One practical consequence that we can surely expect if we break through this significant wall is a floodgate of litigation seeking further expansion. No responsible judge should ever fool themselves into thinking that these cases in the long run are just about the smartest animals. Rather, they're about a beginning. How many animals get legal personhood based on intelligence is just the start. Once this wall is breached, that would serve for many advocates as a stepping stone toward an increasing focus on the capacity to suffer as a basis not for human responsibility legislation. I shouldn't say not for, that might be included, but also, and that's good that that's included, but also much more controversially, to have more of a focus on personhood based on the capacity to suffer. If we got to that point, that would have enormous practical implications for society that need to be thought through and evaluated very carefully before any major changes are made. Any court that contemplates making this very significant change to our legal system would need to think very hard about what the practical consequences might be. Social changes of this magnitude generally should get a lot of guidance and leadership from the popularly elected legislature. As I noted before, it seems likely, it seems to me a no-brainer, absent some huge economic collapse or something like that, which changes our thinking on all sorts of things. But it seems like a no-brainer that we're headed toward Americans, through the democratic process, pushing for more compassionate laws with regard to our animals. We're going in this direction. I think a majority of Americans will be going even stronger in that direction in the coming years. But of course, by the same token, we could say a strong majority of Americans, I don't think I'm being too edgy in guessing that a strong majority of Americans would strongly oppose the idea of saying, let's make animals legal persons. Courts applying common law, as Mr. Wise has pointed out, don't always need to wait for legislatures to act, but the more monumental the potential change and the more that it would violate the views of a strong majority of citizens, the stronger the argument should be that we should listen to the legislatures and take certainly much stronger guidance from the legislatures in that direction than that we've had now before making such a monumental step. One last thought in conclusion. Giving animals personhood does not, not giving animal personhood does not make an animal a mere thing. A mere thing, like a table, has no laws setting forth protections for it. Society is increasingly interested in protecting animals through law, and we should continue to evolve our protections. Felony animal cruelty statutes present a great illustration of this. If you went back 25 years, a relatively small minority of states had animal cruelty as a felony chargeable offense. Some states did, some states have had it for a long, long time, but a minority did 25 years ago. Very rapid evolution on that issue. Last year, I believe it was South Dakota, became the last of all 50 states to change their laws through the democratic process to say, yeah, we think that animal cruelty should be felony eligible. This is the way we need to continue evolving our legal system to provide more appropriate protections of animals that, again, balance in a changing society the needs and interests of humans and the needs and interests of animals. We need to evolve not because animals are persons, but because humans have responsibilities. Thank you.
I think we'll allow a response. There's no need to get up. Let's just use the microphone.
Is it all right if I stand up?
Sure.
Us lawyers, we can't think sitting down. Thank you, Rick. Let me just kind of zoom through a few of the things that I thought of. One of the things that we talk about in our New York cases, and we try to make clear to the courts, is that the people who are keeping the chimpanzees, who we are litigating on behalf of, are not violating any laws at any level. And that what they're doing to them, keeping them in socially isolated, in cages, is perfectly legal. And there are no other alternatives to having this chimpanzee, that chimpanzee, to having him spend his entire life in captivity or even being used in biomedical research. There are no alternatives to the sort of cases that we are bringing. Second, when I heard Rick speaking about some of the maybe policy reasons, perhaps why we should not do what we are doing, I thought back to the case of the Somerset case, which I had spent 3 years thinking about as I was writing the book, and I thought about the arguments that were made to Lord Mansfield as to why James Somerset should be kept a slave and not be freed, not be a person. And some of the arguments that Rick made, were made in the Somerset case. You're opening the door. There are 15,000 slaves out there. They're going to wreak havoc in the world. The legal world will never be the same if you do that. And it took Lord Mansfield, who I personally think is the greatest judge ever to have spoken English. It took Lord Mansfield to say, well, let justice be done, though the heavens may fall, and saying that the common law, that slavery, human slavery he was speaking about, was so odious that the common law would not support it. And he used the word odious. And our arguments is that, well, why is it odious to keep a human being in slavery? Why? And it's because of the fact that it's a dramatic and severe infringement on their autonomy, on the way that they're going to live their lives. And we show that through our scientific affidavits that they too have a huge amount of autonomy, and that slavery, the chimpanzee slavery that they are having to endure is also a dramatic and severe curtailment of their autonomy. The third thing I wanted to address is the fact that Rick was saying that chimpanzees aren't part of the social compact. Before I talked about other humans are not part of the social compact, but chimpanzees are not part of the social compact. What we've done is that we've taken them from Africa or wherever, Africa, we've taken them and we've brought them into our society and made them our slaves, imprisoned them. And to say that, oh, you're not part of our social compact, therefore we can do whatever you want, when they never asked to be part of the social compact, they weren't even on our continent, we brought them here, is simply another rationalization for enslaving an autonomous being. The fourth thing is that the sort of rights that we're seeking for our chimpanzees are, if any of my students are here, you can start to glaze over right now, are a Hofeldian immunity right. We're not seeking a claim right. We're not seeking the kind of right that a human being would have to use their ability to shoulder duties, to have responsibilities. That's what a Hofeldian claim right is. Say we're not asking that the chimpanzees be able to contract or even to be able to exercise power in a power right. We're saying that they have an immunity right, which does not correlate, under Hofeldian theory at least, it does not correlate to a duty as a claim right does, let's say a contractual right. It correlates to a disability, and therefore it makes no sense. It's irrational to require a chimpanzee to be able to demonstrate the ability to shoulder duties and responsibilities in human society in order for them not to be imprisoned by the human society. It's like selling lottery tickets for $1 million where the prize is 100. It just doesn't make any sense at all. Finally, I'll just speak really briefly. We think that whether they intended it or not, the legislature of the state of New York, in setting up a so-called pet trust, has actually given non-human animals legal rights, or at least personhood, in the state of New York. Unlike virtually every other state who set up pet trust, who may have used so-called beneficiary-less trust, the legislature in the state of New York makes it clear that the non-human animals are true beneficiaries. These are not honorary trusts. They are true beneficiaries of these trusts. And under New York law, and probably the law of many other places as well, a beneficiary is a person. And indeed, New York has someone who can enforce their trust for them, which the only court to really have looked at it at all says is the equivalent of a guardian ad litem for a human being. So we argue that. So far, we haven't been able to get the attention of the appellate courts when we raise that argument, but we do think that it is indeed a powerful argument. So thank you very much.
So just a few additional thoughts. First, I just respectfully don't agree that these rulings denying legal personhood dictate what is got to happen with regard to chimpanzees forever. One of the big thrusts that I was trying to make with my talk is to say that we have an evolving democracy. We have an evolving legal system, and the answer, if a chimpanzee is being inappropriately kept, is to go through that legal system, to go through any, I guess you don't even have to necessarily go through existing laws, new laws, things that are within the law that don't necessarily require changes in the law also are available. There are all kinds of avenues that we use in our society all the time for change that don't involve a dramatic shift in our fundamental legal system in terms of defining what a person is. So I don't think it works to say this is the only way we can help chimpanzees, as I've stated. Second, I want to say that the slavery analogy I just don't think holds up, because slavery is different fundamentally, human slavery, because you've got a rational human being, presumably in most cases with moral agency, being held as a slave. This is odious. It makes no sense rationally. They are within the community of humans. They can participate in society. It's just an arbitrary distinction that's keeping them from participating in society. And on that basis, I respectfully think that the concept of slavery doesn't fit with chimpanzees or other intelligent animals. Finally, just a little bit on Hofeld. Since Mr. Wise mentioned his name, I'll dive into that morass as well. I was kind of trying to obliquely reference that in my comments, but let me just be really quickly a little bit more explicit about it. I say it misses the point to argue that, oh, this isn't about rights and responsibilities. This is instead a bodily liberty immunity, freedom from slavery, that doesn't require capacity. One problem with that is we've got incapable humans that we say, yeah, it doesn't matter if you're incapable for purposes of slavery, but we say that because the incapable human is part of the human moral community, rather than saying that is a right that applies to all beings or things or living beings or however you want to define it. What we're dealing with, I'd say, comes before Hofeldian analysis. Hofeld's analysis assumes it's dealing with persons. We're dealing with the question of who is a person, who is a member of society that fits into the categorizations of various rights and protections. Thanks.
All right. So you guys are standing up. Here's some questions from the audience. I guess the first question is for you, Mr. Wise. How do you bring an action on behalf of an animal without the consent of the chattel's owner or in opposition to the owner?
Well, am I turned on here? No.
Yeah, you're on. Just
I am. Just have to be. There we go. Well, in New York, for example, where we bring the common law writ of habeas corpus, there is a procedural statute that allows anyone to bring a common law writ of habeas corpus action on behalf of anyone else who is detained. And that's how we do it. We are them. We are someone. We're the Nonhuman Rights Project, and we simply bring the common law habeas corpus cause of action, on behalf of a chimpanzee who is detained, who appears to be a thing, but we argue that he's actually a person.
I've often wanted to write a novel about that. I mean, you're absolutely right, and that's true in other states, that anybody can bring a habeas corpus. And I thought of, some mob guy who gets imprisoned, and the enemies of the mob file a writ of habeas corpus for him, and they get him out, and he walks out, and then they shoot him.
But if I may say one thing to that,
Yeah.
the cases that we rely upon in the state of New York are cases in which in the antebellum North, you had free black citizens who saw that slaves were being imported into the state of New York. They didn't know who they were. They didn't have any connection to them, but they were still permitted to seek a writ of habeas corpus on their behalf.
Yes, sure.
One quick thought on that, and maybe Mr. Wise might want to respond to this if we have time, but my understanding is that the New York statute on standing says that one has standing to bring an action for themselves or for another person. So my question is, does the personhood issue that we've been discussing today go into the question of standing?
Well, one of the beautiful things about the common law writ of habeas corpus is you really don't need standing because the statutes are so broad, or under the common law, and it is so that it says any person may bring a writ on, or may seek a writ on behalf of anyone else.
But any other person?
I'd have to. I can't remember. Natalie?
I looked it up a couple days ago, so I think that's.
Oh, well, you must be right. So, but indeed, that's what we're arguing, that he is a person, and it hasn't been litigated as to whether or not, say, Tommy is a person. And so if Tommy is a person, then he's being treated very badly and is entitled to a writ of habeas corpus. And if he's not, then we lose.
This again for Professor Wise. How do you know that the animal in captivity really wants to be returned to the wild? Aren't you just projecting your humanity on these non-humans?
This sounds like oral argument. Well, Judge, the way I know that is our experts. You know, we have 100 pages of expert affidavits that tell you that a chimpanzee is an autonomous being. So the answer is because he is a chimpanzee. Chimpanzees genetically, naturally, no more want to live their lives in a cage than would a human. So if a human being could not communicate with me, I think we would still feel confident that she did not want to spend her life in a cage if she could spend it living in an autonomous way. So that's how I know.
Okay. For Professor Cupp, what is your specific alternative? You say evolution of law, but that's not specific. What do you propose in that evolution?
Yeah, no, it's intentionally not specific because it's the entire panoply of society's reaction. You've got how many different jurisdictions that might be capable of making different laws. I would say with all of them, and then we've got to look on a case-by-case basis at what specific changes are appropriate to make, and the decisions aren't always easy. Sometimes they are easy, and what I am intending to focus in on is that for, I think, common sense reasons, we can see we are going to evolve generally. I'm not a seeing eye and can't tell you exactly all the ways in which we are going to evolve or how quickly we're going to evolve, but I think it's, well, I guess anything can be controversial. Maybe if I phrase this the right way, the pace of evolution we've had in the last 20 years, it seems to me, has clearly been different from the pace of evolution that we've had prior to that. So I think we clearly are in a state of evolution with an entire range of questions regarding animals and how they're treated, and I think we're going to continue in the entire range. My point is not on any one issue, but on human responsibility as being the core to all of the decisions.
Okay. I suppose this is for you, Mr. Wise. We have animal rights activists trying to get laws passed and regulations to keep animals like elephants, dolphins, and whales from being held in captivity. For example, there's legislation pending in Washington State right now. Is part of the personhood movement's ultimate agenda the shutting down of all zoos and aquariums?
Well, I really can't speak for the animal rights movement, whatever that means. But I can speak for what we're trying to do, and those non-human animals who are autonomous, which and at least the cetaceans, the great apes, the elephants, their autonomy needs to be legally respected, and they cannot be held in a way that undermines their autonomy or disrespects it. So they would not be allowed to be held in aquariums or zoos, and should go back into the wild if they can be brought there, and if not, they should be brought to a sanctuary to where they could live out their lives.
Professor, do you?
I don't, again, I'm not trying to comment on any specific issues with regard to what should be done, and with regard to how I perceive, I kind of agree with what Mr. Wise said about the animal rights movement, whatever that means. You have just a wide range of people who would have differing views based on a rights paradigm. I understand Mr. Wise's group to have a strong interest in cetaceans, generally just because they're particularly intelligent. And from my perspective, I think you've got to have a particularly high standard for how you treat, under a human responsibility model, you've got to have a particularly high standard for how you treat particularly intelligent animals. We might not always come down differently on specific issues. I know there are a lot of them where we do, but the big distinction, I think, as I understand it, is how we get there. So to me, an animal being more intelligent affects our responsibilities regarding how we think of and treat that animal rather than calling it a person.
You know, New York about 20 years ago abolished the word zoo. It was it was offensive to animals, is what I said in a speech at Harvard. And a professor got up and said, no, it wasn't offensive to animals, it was offensive to the keepers. And I said, why do you assume that when I say animals, I wasn't referring to them?
Very good.
All right. Mr. Wise, how legally can you rationalize a person, such as an ape or a chimpanzee, as being autonomous, but yet, as you stated, unable to care for himself or herself if left to his or her own devices on the street? These notions seem to me inconsistent.
Well, I don't think they are. What I'm saying is that a chimpanzee, has his own culture, his own world. He's another nation. He is very different than are we, and so he cannot be released from a cage in the state of New York and be told to go out and be able to understand how to live in human society in which he will not end up hurting someone or be killed himself. And conversely, that came home to me when I spent some time in Uganda tracking chimpanzees and seeing how they lived. And if you turned me loose there, I wouldn't last very long either.
Are you opposed, again, I guess as both of you, are you opposed to testing drugs and medical devices on animals?
Do you want me to take that first?
Yeah, go ahead.
Okay. I am opposed, and I think it's fair to say the Nonhuman Rights Project would be opposed to violating the bodily liberty or bodily integrity of any autonomous being, which we believe include at least the 4 species of great apes, the 2 species of elephants, and certain cetaceans. So the answer to that would be yes, and period.
Okay. And my thought is that there is a fundamental difference between humans' autonomy and humans' personhood, and animals' autonomy and personhood, so that in appropriate situations, with great attention, perhaps increasing attention given toward care and appropriate compassion for animals, I'm in favor of testing to help save human lives.
Okay.
And benefit them medically, even if it's not a life or death issue.
Okay, I think we're out of time. And anybody else? Any other cards? Okay. Yeah.
If I may
Sure.
say one thing about that, I think, Rick, with great respect, that when you're talking about using a chimpanzee to test on a chimpanzee in order to advance human health, that you are defining a slave.
Let me respond to that, and I appreciate your zeroing in specifically on chimpanzees. I'm not sure that we need to do any more scientific research with chimpanzees. I don't think we're defining a slave because I don't think a chimpanzee is a person. I have a great deal of, I'm very conscious of our need to be very, very thoughtful in how we treat chimpanzees. And I guess my personal perspective is we should not be doing experiments on chimpanzees because of their very high level of mental ability and their closeness to humans, unless it's something truly extreme. If we had Ebola running throughout the world at a higher pace than it seems to be now, as we were afraid of several months ago, I'm going to confess that at some point I would be okay with doing medical experiments on chimpanzees to save human lives and chimpanzee lives. As a matter of fact, Ebola is one of the biggest threats to chimpanzees in the wild right now, and just the different perspective might lead me differently on that.
Okay, I think we're finished. Thank you very much.